Okay. What's going on, y'all? What's going on? What's going on? What is going on? Uh, I really just want to thank all of my subscribers, everybody who shares my videos, who takes time to watch my videos and learn and teach themselves, giving me thumbs up on the content, commenting on the content, asking questions. I really, really like when y'all ask questions because that shows me that you're trying to learn. Um, Thank y'all. Thank you. Thank you. Somebody is. I'm gonna have to call them back. Somebody calling my phone. Um, I am able. My channel is it's monetized now. Because of everybody and because of myself too. So I just want to thank all of us. Me too for putting in the work, and just for y'all too for just studying. I am. I'm going to start a course, a 42 section 1983 lawsuit course. It's going to be a 12-month course. The um the fee for the course is going to be, I want to say, $97.50 a month. The original fee is $75, but YouTube charges I think a 30, they get 30% of the annual revenue or the cut of something like that. So in regards to that, in order for me to make sure that I get at least $75, I had to add $22 and I think 50 cents for the course. The course will be I'll try to do at least 50 members uh only because I don't want to get too many people. I just think it'll get way too out of hand if I had probably maybe 100 people. I think it'll be a little too much for me. So I'm going to stick to 50 people. Um but you have to be a member, and you have to pay the monthly membership fee. I'm thinking about doing, in regards to that, to the course, I'm thinking about doing maybe 2 hour lives per week, maybe either two or just one. I'm not really sure what's it gonna be, but when once I do it, I would like for everybody who's interested in it to have their questions and everything ready because I'm going to be answering all of your questions right then and there. I'm going to be teaching you how to properly file your complaint, file motions, file discovery, and how to properly prosecute your case and win, because you can do this. It is a little difficult because y'all know these people, they just don't play fair. They just, if you're a pro se litigant, it just seems like that they don't want to see you win. It's like that nigga of what was that movie Belly? I think it was Belly, when the guy was sitting outside with the glasses on, had the little a little bob in his head or some shit like that, and he was eating a banana and he was looking at the other guys. Y'all hit that like button for me, by the way. And he was like, I don't like that shit. I'm gonna drop a dime on them niggas, something like that. They just do shit like that. That's how they are. But I promise y'all, this stuff is way easier than you think. And if you can prosecute a 42 section 1983 lawsuit, then you can litigate a common law lawsuit. You can litigate any lawsuit. You can defend yourself in a criminal prosecution against yourself, because all of this stuff is the exact same thing. Just like they can't just like you can't file a 42 section 1983 lawsuit in court and say the police officer unlawfully arrested you. You can't do that unless you have facts to support that conclusion, to show to the court and to show to the police officer's attorney who you're suing. They cannot file any complaint or indict anything like that against you based on legal conclusions without facts to support those conclusions. because when you do that, you violate due process. When they do that, they violate due process. How do you litigate a common law lawsuit? It's the same thing, Jr. And when like it is literally the same thing. It's the same thing. Um, for a 42 section 1983 lawsuit is a common law lawsuit. Well, let me rephrase that. It's a colorable common law lawsuit. It's the appearance of a common law lawsuit, but it's not. The only distinction is you're litigating the 42 section 1983 lawsuit under a statute, but the Constitution is superior to the statute. So what you're doing is you're instead of invoking the court's original jurisdiction under a statute, you invoke the court's original jurisdiction under the Constitution. That's what you're doing. All of this, I promise y'all, is the same thing. And instead of paying the filing fee in Federal Reserve notes, you would simply pay the filing fee in either something of substance like gold or silver, something like that. All of this stuff is easy. It's all of this stuff is easy. I'm not. Let me see if I can turn my super chats on. Probably. Did I turn it on? I probably didn't turn it on. But anyway, um, I strongly advise y'all. Y'all just if y'all think that I'm just in this for the money, you're wrong because I can be charging way more money for this so-called money for this than $75 a month. I really could because this stuff is it is mentally exhausting. I'm not even finna lie to you. It is mentally exhausting because you have to put in numerous and extensive amount of time and research into learning this stuff. Y'all hit that like button for me if y'all don't mind. Um, but you can do it, and it can be done. It can be done. I've done it. I've done it. I learned what I learned now by one, of course I had to do my own research, but I got a seminar um on a flash drive from a guy out of uh uh out of a guy out of Missouri named Jerry. So Jerry, if you're ever watching this video, thank you. It's a white guy named Jerry. He gave me this seminar. The guy in the seminar teaching the seminar, he goes by the name Rick Schramm. Not sure where he was from, but in this seminar, he's telling you how to prosecute this case. Um, the seminar is extremely long. So what I had to do is I just had to keep listening to it and keep listening to it and keep listening, keep listening and keep listening and keep listening and keep listening. And then once I, um, kept listening to it because they provide you with the cases that you need to read too. Motherfucker, you gonna have to read. I'm not you are going to have to read and you're gonna have to study. You're gonna need a lot of law dictionaries. Probably I prefer the eighth edition, the fourth edition, and the fifth edition. But my overall favorite is the eighth edition. Um Also, you're going to have to read a lot of cases. And I mean a lot of cases. I'm not joking. I, y'all, I am not exaggerating. I have read so many cases, I don't have to read them anymore in regards to the Fourth Amendment when it comes to prosecuting 42 Section 1983 lawsuits because I already know what the exceptions are in to justify an unlawful search. I mean, let me rephrase that. To justify a warrantless search and seizure of my person. I already know what the exceptions are because I've read the cases so many times. Y'all hit that like button for me. Hit that like button for me, y'all. Hit that like button for me. I don't think I turned my super chats on, man. But anyway, my channels, I can monetize my channel now, so I'm able to receive donations via the channel. And I'm able to have the memberships and stuff like that. So that's what I'm gonna do. Jr. knows. He know. Jr. How long have you been prosecuting your case so far in federal court. This man, look, it's no joke. I just got through working, drafting a complaint for somebody. It took me probably almost 2 weeks to draft a complaint. Well, yeah, I would say probably about maybe about a week and a little and a half, something like that. But I had to read so many cases. This was new to me in regards to his particular case. His case was new to me, and I learned a lot just by drafting his case. I learned so much. That's how I know that you can sue these. Well, that's how I learned that you can sue these people 20, 30, fucking 40 years later down the road, once your conviction is vacated. Once your conviction is vacated, on the date that it's vacated, generally speaking, your clock starts ticking on when you can file your 42 section 1983 lawsuit in federal court. Easy. January 2023. I bet you did a lot of reading too, didn't it, Jr.? You ain't got to tell me, man. I bet you've done a lot of reading. Not only that, you studying this stuff, but the attorney, their attorney, he's not gonna make this easy for you, man. These man, look, you can when you're going through discovery and you're asking for evidence, you're thinking that they're just supposed to give you this evidence, that they're just going to willingly give you the evidence that you need to prove your case against them. No, that is not what they're gonna do. They're gonna play dumb. They're gonna act like they don't know what the hell you talking about. That's what they're gonna do. They're gonna test you. That's what they're gonna do. And when you just fed up with them, you're like, you know what? Okay, you got to take it to the judge then, because that's what they're gonna do. You might have to reach out to them maybe 2 or 3 times or something like that, maybe 4, to try to get the evidence that you need. And then probably the 4th time when you reach out to them, they just flat out tell you what the fuck they should have been told you. Uh, they should have been told you the first time is, I'm not giving you this evidence. I had an attorney tell me that when I was asking for his client's financial information. It took me about 3 times before I got an answer from him. And then he just flat out told me, we on the phone. He flat out told me, I'm not giving you my client's financial information. And I was like, all right, man. What? And then I took it to the judge. And the judge ordered him to tell his clients to give me their financial information. And they gave it to me in an affidavit. I don't know if they were telling the truth, but I got it. Anyway, y'all, this stuff is easy, man. It's easy. Easy, 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 easy. Have you learned a lot, JR? I already know you have, but have you learned a lot? You're going to learn a lot just by from making the mistakes. That's where you learn from. You learn by making the mistakes. That's how I learned. But all of this stuff is the same, man. It's all the same. This is how I'm gonna explain something to y'all, man. And I'll be talking about this a lot more in my for the members. When you register for a membership or whatever, when you sign up for YouTube for a membership, I'll be talking about this a lot then. But you use the Constitution was created under the common law. Okay, the people created the Constitution. So what happened was this, y'all. The people created their own courts. Okay, the sovereign's courts are called courts of general jurisdiction, aka superior courts. Okay, and they are in the exclusive, in my opinion, they are in the exclusive jurisdiction of common law and equity. That is where living flesh and blood men and women litigate their cases at. Okay, and legal persons or juristic persons or legal fictions and stuff like that, they litigate everything over within the jurisdiction of fiction. That's what I call it, the jurisdiction of fiction, because everything in that jurisdiction is a fiction. So, like corporations, they litigate in the jurisdiction of admiralty and maritime and stuff like that because they're doing business over here. Okay, but even though there are men and women, living flesh and blood men and women litigating within that jurisdiction, they're doing it under another name. They're doing it under their person. That's what they're doing because legally, their person has been granted privileges and rights and immunities by the legislature. Okay, so corporations have to enforce their own rights and so on and so forth like that. So like for example, I have a business. The business it's not real. It can't do anything. So I have to do everything on behalf of it. But I'm the only one that can do that because I created it. I have some sort of equitable interest in this business or some sort of legal interest or whatever you want to call it in this business. So I would litigate in that particular jurisdiction. But how you invoke common law jurisdiction is you would use an article in your state constitution and you would plead facts to show that your right has been violated. And then you would incorporate all of these facts into each of these causes of actions at the bottom of your complaint. And then you're going to ask for monetary damages or something like that because when you monetary damages is a common law remedy. Okay, and you're not going to pay the filing fee in Federal Reserve notes. You're going to pay the filing fee in either gold or silver. Would this help me chat at Monopoly? I don't know what that means. What's good, AJ? What's good? What's good? So, yeah, I really think people really be overthinking this stuff because it's not as hard as we think it is. Don't get me wrong. Like when I first started this, I didn't understand none of this shit. I didn't know what I was doing, but I couldn't afford an attorney. And you not just finna just keep running over me and violating my right. You're not finna do that to me. You are not going to do that to me. And I just passively and just I don't care. Like you're not finna do that to me. It's just not gonna happen. It's not gonna happen. I'm a rebel anyway. It's just not gonna happen. If I grew up during the during this probably the 50s or 60s, I know for a fact that I would be a Black Panther. I already know that. Um, man, you a trip, top dog. Um, but anyway, all this stuff is easy, y'all. This is the easiest thing that I have ever done in my life. I got a transcript right here. This is a transcript. I'm gonna show you how thick this damn thing is because I'm going through an appeal right here. You see this? This shit look like a damn book. This is a transcript this is the entire record of everything relevant to my appeal. And in it, I have the transcripts from like 2 or 3 hearings or something like that. I'm gonna show it to y'all. Not everything because I'm just extremely private like that, but I'm going to show y'all. Well, this judge, he's saying, well, I read over your paperwork. You seem like a very intelligent guy. This looks very well written and stuff like that. The reason why I'm saying that is just to let people know that I know what the fuck I'm doing. If I don't know what I'm doing, I'm gonna tell you I don't study that. Like I don't think I would be able to help you. You know, monopoly is an analogy some use to describe all of this. Yeah, that's right. I mean, it is monopoly money. Anything can be money. When I tell you anything, and I mean anything can be money. Anything can be money. Um, hell of rocks, leaves, fruit, vegetables, water, a bucket of piss, I mean anything. If 1 million people believe that this has value, it doesn't even have to be a million people. If for example, it can be a two-party transaction. If I see something of value, uh, um, in something that you're giving me in exchange for something that I'm giving you, and we both see equal value or something like that in that particular transaction, and we exchange the goods or whatever it is, then that is a valid transaction. That's valid. Anything can be money. That's what they don't want people to know. That's why I don't care if they make if they take away the dollar, or I don't care about that, because I know anything can be money. That's why you need to grow your own food. And I am in the process of trying to do that. As soon as I get me some land, that is exactly what I'm doing. I'm growing my own food. I'm gonna get me a well. I don't have time for this, because you're a sitting duck if you do if you're not in control of your own uh what do they call it, the things that are necessary for you to survive, like food, water, shelter, stuff like that. If you don't control that, and somebody else can just stop you from having that whenever they want, like, you in trouble, fam. You in trouble. You in trouble. So yeah, man. I really just want to thank y'all, man. That's really why I came here tonight. I wasn't even gonna go live today, but my channel I'm able to monetize my channel now, and donations and stuff like that, man. So I really appreciate it. I really appreciate everything that my subscribers do. But I would like for y'all to start asking questions more. And I'll answer the questions to the best of my ability. Um, Man, I learned a ton over the past 3 years. Yeah, and you only gonna get better, Jr. The more you practice, the better you're gonna get, man. You only gonna get better. Man, y'all should see the face on some of these attorneys when I hand them my paperwork, because excuse me, they don't do their own paperwork. I do all of my paperwork. I draft the motions. I draft the pleadings. I draft all of the discovery. I make the phone calls. I mail off all of the documents. I hire a process server to serve the defendant, or a private investigator or something like. I do all of that. If I don't think you can do that, Jr. If family court is not a court of general jurisdiction, then no, you can't do that, Jr. I don't think family court is a court of general jurisdiction anyway. I think family court is a court of limited jurisdiction. Courts of so-called courts of limited jurisdiction are administrative agencies. They're in there following statutory procedures, and they're in there enforcing statutes. That's what they're in there doing. And it's certain stuff that they can do, and it's certain stuff that they can't do. That's why they call it courts of limited jurisdiction. It just blowing my phone up, y'all. Ugh, blowing my phone up. Uh, you can only invoke common law jurisdiction in courts of general jurisdiction, aka superior courts. Those are the people's courts. The inferior courts, aka the courts of limited jurisdiction, those are the courts for the fictions, the legal persons, the juristic persons, the juridical persons that have their rights granted to them by the government via positive law. Your rights do not come from government. Civil rights come from the government. Civil rights come from statutes. Yeah, that's part of the game. I would agree with that. And fraud. There's a lot of fraud going on here. A whole lot of that. Whole lot of that. I would say something along the lines of, like, when if they threaten me in contempt, I would say something along the lines of well, you're not, I don't want to be held in contempt, but if the court is seriously thinking about considering holding me in contempt, I would have to ask that, does this court thinks that its commercial bond will outstand the commercial liability for unlawfully holding me in contempt, because there are no facts present thus far before this so-called court or whatever, that would allow this court to lawfully hold me in contempt, because I know when I'm lawfully held in contempt and when I'm unlawfully held in contempt. What have I done, Your Honor? What have I willfully done or willfully failed to do, or did I? What is it? I would say something along the lines of that. Oaths, bonds, foreign registration. I'm not denying. Well, if you don't appear, then wanting to go to jail. Yeah, they'll file a lien against you. That's what they'll do. File a lien against your legal person or some sort of like an attachment. That's really what it is. It's an attachment. That's really what it is. But I mean, I would just make a special appearance or something like that. And you don't have to go to court to make an appearance. You can appear via you can appear on a piece of paper or something like that. You don't have to actually go. This is all games, y'all. Y'all, this is all games. I showed y'all. I mean, I read y'all a case probably 2 weeks ago, um, where a guy, he filed paperwork and made a special appearance as distinguished from a general appearance solely for to challenge the jurisdiction of the court. And the so-called, well, the chancellor in that particular case said that this was in no sense a general or special appearance. And he was actually in the court and he filed paperwork in the court, and they still said that wasn't an appearance. It's an Alabama case, Jr. If that's the case, if you're talking about the case that I did a video on, it's an Alabama case. Look up I think it's called filing motions does not grant jurisdiction or something like that. 100% proof or something like that. That's not the only case. There are some more of them. There's a lot of cases out here that are y'all need to read old cases, man. If you're really trying to find out what is going on, you got to read these old cases. That's how I found an old case that says jurisdiction is either granted by the court via issuance of proper legal service upon the defendant or the defendant's consent. But when you go to court and you start talking like this, they want to call you crazy, call you a sovereign citizen and all this BS. If you can consent to the court having if you can choose not to consent or to consent to a court's jurisdiction, then surely you can consent to then surely you can choose not to consent or to consent to an unlawful arrest. How can you if these people got y'all thinking that people are crazy when people do not consent to certain shit? Well, if that's the case, then how can you consent to a police officer coming into your house or not consent to a police officer coming to your house? Or, yeah, coming into your house or searching your car or something like. Where's the line? You see how this bull? It just don't make sense to me. It don't make sense to me. How can you consent to having, how can two adults consent to having sex, but you can't consent to a court's jurisdiction, or you can't choose not to consent to a court's jurisdiction, or it just don't make sense to me. That's why I started to do I started to use that tactic with Yusuf L. He mentions it a lot. He uses the tactic. He uses the tactic. He basically uses everything they say against them. That's what I do. So when they start calling me crazy or what else, well, and honestly, I'm just repeating what your colleagues are saying. And this is not just one of your colleagues. This is probably 1,000 of your colleagues. And each of them all over the 50 states within the United States of America, not the United States, they all say that the people are sovereign. As a matter of fact, Your Honor, here I have the case citations right here from each of the so-called 50 states within the union, and these are just they're just look cursory citations, but they're going to tell you that the people are sovereign in all of these states within the union. I think you know that though, Your Honor. I'm going to reasonably conclude, because you've been doing this for 40 years. So I'm going to reasonably conclude that you either know this or you should know this. Yeah, he used to do say that. He do say that. Top dog. He say sovereign citizen. He said when you call me a sovereign citizen, you're really calling me a nigga. He do say that. The singularity is not far off, and then the mark, the trap was shut. I've learned so much, y'all. So much, so much, so much, so much. I don't even some of this stuff I don't even have to read cases no more, man. I can just do it off the top of my head. I'm gonna look at the camera and I'm gonna just give y'all an example. Reasonable suspicion is predicated upon specific, articulable facts that a crime has been, is being, or is about to be committed. Probable cause is a mixed question of law and fact, meaning the facts. Let me rephrase. Yeah, the facts apply. I mean, let me see. How do I? I'm trying to see how do I word this shit without confusing y'all. I know the reasonable suspicion, but the probable cause when it's a little tricky, and I don't want to word it in a way that I confuse y'all. But probable cause is a mixed question of law and fact, meaning the facts and the relevant case law applied to those facts will always determine if you have been lawfully arrested or unlawfully arrested. It's the same thing, y'all. Same thing. The image that can speak. And I promise y'all can do this. I promise you can do it. In my opinion, one of the most important amendments in your state constitution and the federal constitution is the Fourth Amendment. I don't know what the Fourth Amendment is in your state constitution, but you need to know all of that jurisprudence because that is going. I mean, that that is the amendment that is applicable every time, almost every time, the government starts to intrude into your private life. Is that amendment right there? You need to know what a consensual encounter is, and you need to know what a non-consensual encounter is. You need to know what probable cause is, what reasonable suspicion is, and what your consent is. You need to know all of that stuff. SGI, what did I do last? I was out of it last night. SG, I was so tired because I was on the phone yesterday, um, almost all day with the guy who I'm helping, who I was helping finish his complaint, and I was on the phone like damn near all day. And I was just tired, and I was out of it last night. I was out of it, so I don't think I'm gonna put that live back up. I think I'm just gonna do another one, to supplement that one or whatever. Y'all hit that like button if you haven't already. I would really appreciate it. Stop being stingy. Stop being stingy, man. I'm giving y'all my time, my experience, and my expertise. Even though I wouldn't consider myself not an expert quite yet, not right now, but I would consider myself extremely experienced because I know what I'm doing. Yeah, she called in. She called in. I let her vent for shit, probably about a damn near an hour. Um, she had a lot going on, man. I really hate that happened to her too, man. I really do. But I mean, it's happening to people all over the country, man, because these thieves, um, they don't make this stuff plain to where you can see it. I mean, not to where you can see it, to where you can understand it. They're hiding behind this legalese, speaking in riddles and all this shit. So that's what's going on. That is what's going on. I really hate that happened to her though, man. I really do. It's crazy, man. It's crazy. Okay, back to work was on break. Okay, top dog. Peace, man. Peace. How did you learn what to know to start out? Man, I'm gonna call you TD. TD, I didn't, bro, like, I just started reading cases. Like, I would go on Google and I would type in unlawful arrest, reasonable suspicion, Alabama case text. Those are the words that I would type in. And then Google will pull up a case with those words that I typed in, and then I would go and read that case. And I would just click on to other cases and click on to other cases and click on to other cases and read those cases until it just started clicking for me. And I was like, so that's what reasonable suspicion is. Okay. So that's what probable cause is. Okay, cool, cool, okay. So how do I apply this to my case? Like how are they determining if this arrest is unlawful or unlawful? And I just thought it just clicked. It was like, well, it's based on the facts because they're always saying that these facts are insufficient for something. And I'm like, damn. So it must be about the facts of the case. The facts must be extremely important. And it just clicked for me. And it was always about the facts. It's always about the facts. Always about the facts. Oh, I was waiting for her to say. How did she say? I forgot. I forgot what she said, SG. I forgot what she said, but in my opinion, they stole her house. In my opinion, because that will, they never contested the validity of the will. You know, you can't force somebody to come to court who hasn't caused you an injury. You can't do that. In my opinion, you can't. You can't do that. Who hasn't violated your rights? You know, you just can't do that. But I think that's what happened in her case. They were trying to force her to come to court. You know, shit like that, and she kept just putting it off and putting it off, and she would file little stuff here and there. I think to the effect to where she was possibly challenging jurisdiction or something like that. I'm not really sure, but I would I don't know too much about it. I would have to ask her. Um, uh, I'm gonna show y'all what y'all need. Now, this is my second time doing this now, and I haven't had too many people ask me for this document. So I'm gonna show you what you need. I'm gonna pull it up on the screen. I'm gonna screen share it right now. I'm gonna pull it up on the screen. Turn the camera off, and we're gonna screen share. This is what you need right here. This document right here is what you need. Let me go to page 1. This is the document that y'all need right here. This is what you need. He might have done another one, but this is what you need. This is, I promise, this is the most important, one of the most important amendments in your state constitution and federal constitution that you need to know. As a matter of fact, you're going to see that he's gonna cite the Fourth Amendment, and he's gonna go and cite the Fourth Amendment. I mean the identical amendment within the state constitution that it's like it's the same as the Fourth Amendment in your state constitution is what I'm trying to say. So that's why he says see also the nearly identical California Constitution, Article 1, Section 13. So in other words, Article 1, Section 13 of the California Constitution is essentially the Fourth Amendment. It's the same shit. You see how it looks damn near the same? The right, I'm gonna read y'all already know. Well, I'll read the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now let's go and read right here. It's the same shit, y'all. Same thing. You need to find out what the Fourth Amendment equivalent in your state constitution is. This is the California Constitution, Article 1, Section 13. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures may not be violated, and a warrant may not issue except on probable cause supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. That shit damn near the same. Now, this word may, y'all need to go and read cases in California so that the Supreme Court for California can tell y'all what this word may means, because may meaning may it may not mean that they have discretion to violate this or not. I don't think that's what it means, in my opinion. So I would go and read cases to substantiate that, and they'll explain it to you what it means. Scope. Look at this, man. This is what you need, man. This is what y'all need. When people if you're watching this video, when you see this video, you need to be either sending me an email or commenting on commenting your email address in the comment section of this video, so I can send you this document. This is what you need. This ain't nothing but case law, man. Nothing but case law. That's all this is. Nothing but case law. Telling you what your rights are. Telling you what they can and can't do. You're going to see Supreme Court cases in here from the United States, from the California. You're going to see Ninth Circuit, because that's the federal district. I mean, that's the U.S. Court of Appeals for the all U.S. district courts in California. I forgot the other U.S. district courts, but the Ninth Circuit also hears cases from other U.S. district courts. I want to say maybe Oregon, Washington, probably Nevada, something like that. I'm guessing though, because I'm not really sure. Probably the appellate court in California. You know, you're gonna see all of that stuff, man. This is what you need, man. If you don't know your rights, you don't have no rights. I'm not sure. I can't remember who said that in the video. I think it was I was watching a video, and I think it was a guy by the name Carl Miller. If you don't know your rights, then you don't have no rights. And you a damn fool if you think that these administrative law judges are going to tell you what your rights are, because that is not their job. In my opinion, they're in there to adjudicate public policy statutes. So their interest, in my opinion, is going to the corporate state's interest is going to supersede yours, generally speaking. Let's see. See this right here? Remedy for violations, the exclusionary rule. Wherever there is a right, there is a remedy. That is a legal maximum. I've read cases on that. Wherever there is a right, there is a remedy. So whenever, the exclusionary rule is not an individual right and applies only where it results in appreciable deterrence. The rule of reasonableness. Also, in otherwise lawful seizure can violate the Fourth Amendment if it is executed in an unreasonable manner. You need this word right here in reference to the Fourth Amendment, and in reference to qualified immunity and a reasonable officer. Not, you need to know what the fuck that word means. That's what you need to know. Y'all can see I'm not looking at nothing, y'all, other than this screen right here. And I can tell you what a reasonable officer would do based on the facts and circumstances, and what a reasonable officer would not do based on the facts and circumstances. A reasonable officer would not kick my door in without a warrant, without my permission, and without exigent circumstances. A reasonable officer would not do that, because a reasonable officer knows, or either should have known, that is the violation of a clearly established constitutionally protected right, of which a reasonable officer would have known or should have known about. So they are not going to get immunity when they do that. They probably gonna get shot if they do that too, by the way. I don't play that. You got me fucked up. Okay, I just got your text, Jr. I got you. I'll send it to you, Jr. Just got it. Thank you. That's what you're supposed to do. You need to find a way to contact. You need this document because all of this shit, most of it is going to be this. It's going to be applicable in your so-called state too, because they're modeling it after federal law. That's what they're doing. You need this document. This is 788 pages of nothing but Fourth Amendment jurisprudence that was drafted by a retired district attorney out of California. Not that not that it matters in my opinion that he's an attorney, but it's just the fact that, hey, I mean, ain't no telling how long he's been doing this. This is from 2014. I'm gonna this stuff right here. I think I'm gonna save this for my class. I mean, I'm still like, if you send me an email or something like that, or you give me your email address, I'll send you this document. But for my class that I'm teaching, um, in regards to the 42 Section 1983 lawsuits, I'm going to be using this a lot, a whole lot. This is just for teaching purposes. I'm not selling you any of this because it's not mine. I didn't, it's just not mine. I didn't draft it. I think he did another one too. I think he has an updated version one, but I don't really know. I will have to go and check. Let's see. Let me go back to the chat and check. Look at this, y'all. Look at this. I think I read this in another video. It took these people 26 and a half hours to obtain a search warrant for a residence while the residence was detained if the occupant was kept from re-entering. If you're not free to leave, your ass is arrested. You arrested, fam. Traffic stop too. If a reasonable person would feel that she or he is not free to leave based on all of the facts and circumstances that they have witnessed, then they are, as a matter of law, arrested. It's over with, and the Fourth Amendment applies. I'm gonna turn the screen share off. If y'all want me to keep going over this document, let me know, and I'll go back over it. But if not, I'm just gonna turn the screen share off, and I'll turn the camera back on. But that's what you need. You need that document. Hit that like button, y'all, if y'all don't mind. Let's see. Can you go after an attorney representing the officer? What do you mean, JR? What do you mean? Sometimes in statutes there's a section for construction of terms near the definitions. Yeah, that's right. That's right, SG. Sometimes may is in there and it tells you how it is to be construed for that chapter or title. Yeah, you're right about that. Sure live. Sure right about that. You're right about that. Man, look, these people, I'm gonna have to pull up. So I would have to pull up some of these cases just to show y'all. Like I've heard, there's a saying that I have actually heard that there are no magic words, when it comes to filing paperwork. And I used to agree with that until I discovered that there are in fact magic words. Because it matters what you say in that lawsuit because one, you're a witness. So you have to be very careful when you're drafting your complaint or any damn thing, because anything you say can and will be used against you. It can be used against you to dismiss your case, to get you sent to jail, stuff like that. So it matters what you say in these pleadings in court. I'm telling you what I know, not what I think. In my opinion, there is a science, in my opinion, to drafting this stuff. Now, in my opinion, also, I've seen complaints drafted by law firms, and they don't look as good as mine. But I mean, they still get their clients, they still win their clients' cases and stuff like that. But generally speaking, I think they win their clients' cases because it doesn't matter how it looks; it matters what it actually says. It's the substance of the motion or the pleadings or whatever that really, really, really matters. That's what really matters. But me, I'm just very detail oriented. And I like to do my stuff in a certain way. I like for my stuff to look good because I'm so-called pro se. I've never went to law school for this stuff. So I like to stand out. I like to stand out in my shit. So yeah. Um I'll probably be on here probably about another 10 minutes and I'm gonna get on up off here, y'all. But also I do want to say this. Y'all don't have to, but I would really appreciate it. Sometimes when I'm live, that y'all make donations because I have this computer that I just bought was probably it was I actually called it on sale. So it was probably maybe about I think it was about $750 or something like that. I bought this computer so that I can start doing these lives to help y'all. And so that I could um increase the quality of my live videos, to help y'all when I'm going live and stuff like that. So any donations that you give me, of course, it's going to be for my time and more equipment to help y'all. Um, so yeah, let's see, where are we at? All right. Anyway, man, y'all, I don't know how many times I'm gonna have to say this, y'all. All of this stuff is easy, man. It's easy. I know it's a little difficult, but don't give up. One day it's gonna click for you. I promise you, it's just going to click for you one day. Let me see, Jr. Is any of this, like, since you've been studying, has any of this stuff just started clicking for you now, to where you just understand it, you know what you're looking for, and when you see what you're looking for, and it's not legally sufficient, you know what you're supposed to do. You know how to draft the arguments, you know how to draft the paperwork, you know how to serve all of the defendants, so on and so forth like that. That's all you got to do. That's it right there. You see that man say, man, you just have to study. That's all you got to do. That's it. Man, I promise y'all. I promise y'all. I'm not telling y'all anything different than what these law professors are telling these law school students. I ain't telling you nothing different other than the nature of the action, and all of these courts were separate courts and they merged all the courts together, and since they merged all the courts together, they merged all the rules of procedure together. I mean, that's about it. Can you create subfiles to reference? Um, what do you mean subfiles, Jr? Can you create subfiles to reference? What do you mean? I don't know. I'm a little lost. What you mean by that, Jr? Hit that like button for me if y'all haven't already. Stop being stingy. Y'all, boy, ooh, y'all some stingy. Ooh, y'all some stingy motherfuckers, boy. Y'all stingy, boy. All you got, all it take is this, and then that's it. That's all you got to do. I'm out now trying to get a computer. Create you some sub files to create you some sub. Oh, you were telling me to create some sub files to reference. Oh, okay, yeah. Now All you got to do is just read cases, man. Because let me tell y'all something, man. All of this is going to. I'm not sure if y'all are going to be surprised by this, but all of this shit is made up, y'all. All of this shit, they just made up all this shit. Now, don't get me wrong, because I do see the benefits in having law and order. Because if we didn't have it, I do genuinely believe that there would be chaos. Uh, you know, so I get it, but back to what I was saying, they made this shit up, y'all. All of this shit is made up. No, none of these judges. Let me tell y'all what these judges are. These so-called judges are just repeating opinions of other judges, so-called judges. That's all they do. That is it. And some of them, when they don't agree, they'll let me plug my computer up, y'all, because it's going dead. When they don't agree, they they file dissenting opinions. Give me a second, y'all. Plug my laptop up. They file dissenting opinions. Or some of like sometimes it causes so much friction within the courts because they don't know how to rule on a particular thing. Like they might be divided on what to do. So some of them might think that you may have to rule this way. Some of them might think that you might have to rule that way. It just they don't know, man. I mean, they can understand the language. Don't get me wrong. And some of these people in this particular field are extremely intelligent. But that's because they've been doing this shit forever. These people read every day. You know how many cases they read? They don't even have to read cases anymore because they just know this stuff. Let me see. So for the people who are studying, you need to create folder to reference to educate yourself. Oh yeah, that's right. That's right. Basically like a study guide. Yeah, that's right, JR. I agree with that. I have a hearing coming up for the second time to vacate my child support order against me. I put together a motion for summary judgment to force them to answer for their due process violations. Um, I don't know. I would have to. I need to get what you call. I'm gonna have to set up another call with him, and I'm gonna actually pay him to come on here and pay him for his time. Probably give him about $100 or something like that. Pay him for his time to come on here and answer questions for y'all in regards to that child support thing, cause he know what the fuck he doing. I ain't like I'm certain that he knows what the fuck he doing, and for him to come on here and give y'all an update on his case in federal court and in state court too, because he's filing a lawsuit. Well, I think he's challenging the lawfulness. They always say constitutionality. I'm gonna say the lawfulness of a statute in Georgia, in regards to the child support laws or something like that. And there's a little corruption going on in Georgia, and I need him to update y'all on that. I sent a copy certified mail to their attorney, and they still haven't accepted it. Have you seen case law where regular mail isn't accepted as proper service? Um, I'm gonna tell you like this, SG. When you in a situation like that, hire you a process server. That's what you need to do. That's what I did in my case. It cost me $75, but I got that back once I settled my case. But you need to hire you a process server because they do shit like this. Now, there's another way that you can serve them. I'm not sure if this would be sufficient in this particular case, but they call it service by publication. Have you heard what? Do you know what that is, SG? If you don't, let me know, and I'm gonna pull it up on the screen. I'm gonna screen share it, and I'm gonna read it to you so everybody can know what it is. Service by publication. That's what it's called. Let's see. JR, I'm proud of you, man. Proud of you, man. You didn't really need too many consultations from me. I think you just really needed reassurance. For somebody to tell you that you were right. Which I do. I do that sometimes too. I do, but it's too late for that. Um, I don't. I don't. Let me see. Every region has a public newspaper that is worthy of that term. I don't know if it's too late. I don't know, SG. Why do you say it's too late? I don't see how service by publication is too late. If service of process, if you're trying to serve them certified, you probably be talking about the time frame within the rule that is allowed for you to serve them or something like that. I think that's what you're talking about. I have exhibits in there anyway. Too much for the general public. Okay. Hearing is next week. Okay, I got you, SG. I forgot to send you this email. I'm gonna send you this email right now, JR. I almost forgot, man. I'm sorry. Let me send you this email right now. All right. Promise. Promise you niggas. Give me a second, y'all. I'm sending JR this email right now. I promise you niggas. Google. I keep it real. I keep it on. I promise. Where we at? Right about the time span. They both hold the same weight. Every region has a public newspaper that is worthy of that term. What term do you mean, Nash? What you talking about? You're probably talking about service by publication, I think. I'm not sure. But I keep it real. I keep it 100. I promise. Keep it 1,000. I promise. Um, case law. The guy who I was drafting his complaint for y'all, I think we got them. I'm about 99% sure we got them. And they ain't getting out of that unless this judge just don't do what he's supposed to do. Not a black judge. I don't know if that makes any difference. I doubt that it makes a difference, but they not getting out of that. They filed a motion to dismiss in his case, and they filed a memorandum of law in support of their motion to dismiss. And so I read over it, and I just started redrafting his complaint. So we filed a notice of motion, a motion for leave of court to amend the complaint, and we filed his complaint. And I think there's a lot of exhibits attached to it too. And I requested the court to take judicial notice of the stenographic record of the proceedings in the trial court in which his motion to suppress hearing was granted, and the state moved to dismiss all of the so-called charges against his person that day. Man, look here. Rule 2, let me see, Federal Rules of Evidence, Rule 201A1 or something like that, or B1, allows you to request the court to take judicial notice of adjudicative facts. Man, I don't know what they gonna do when they see that, but I wish I could see the look on their face when they see it, because that shit is gonna be hilarious. I'll throw a copy in the mail. They had balls to rip me off but tucked tail when it came time to face the music. Yeah, the guy who sued the state of Georgia, the child support laws, they are actively, I'm not sure if they're still doing it, but they were actively avoiding service of process so that the court could not get jurisdiction to properly adjudicate the case. I wonder why. Hmm. Could it be that he knows what the fuck he's talking about? And because his arguments have merit? And because they probably, let me rephrase it, and because they knew this shit, but they still did it in regards to child support and all this stuff. These folks know what they doing, man. You a fool. Y'all are, if you think these people do not know what they are doing, you are a fool. It's really about if a man should knowingly be looking for or already know the info you're looking for to get him. I would agree with that, Nash. I would agree with that. Would a reasonable person know or should have known? Something along those lines. I think that's what you're talking about, Nash. I would agree with that. Yep, I would agree with that. I'm trying to. Did I spell subscribers right, y'all? Because I'm dyslexic, y'all. Something I'm dyslexic as hell sometimes. I filed requests in September for the records. Oh boy. Did you? Well, I don't know how they do it there. But I would say, based on your comments, SG, in the videos and stuff like that, I think you do your due diligence. I think you do your homework. So I'm gonna trust that you're right about what you're saying and pursuing in that particular matter. How is the quality of this video, y'all? Is the quality of the video a lot better than what it's normally was, or is it about the same? JR, I sent that document. Let me know if you got it. If you're still watching, let me know if you got it. I can't wait to eat, y'all. Tomorrow. Can't wait to eat. I don't really too much care about Thanksgiving. I just want to see my family, get some good laughs, hug some people, tell them I love them, and eat. Uh, Excuse me, y'all. Sorry about that. Don't know where that came from. Yep, yep, yep. So I'm about to get on up out of here, y'all. Here, buddy. All right, cool, JR. Cool, cool. I'm about to get ready to get on up out of here. I'm tired. Not as tired as I was yesterday, but I'm a little tired. But before I go, I gotta tell y'all thank you again. Thank you, thank you, thank you, thank you. And okay, cool, cool. Appreciate that, JR. But if y'all, this really goes out to anybody who wants to learn how to properly, file their lawsuits um in federal court. The 42 section 1983 lawsuit. Whether y'all know it or not, this is going to teach you how to draft any type of paperwork. When I say any type of paperwork, I mean anything. All of this shit is the same thing. It's gonna teach you that. At least I think it'll teach you that because it taught me that. Nobody taught me how to do motions or anything and stuff like that. I just learned that stuff by doing the other stuff, or by going to Google and looking at the formats and stuff like that, and by going to the law library, stuff like that. That's how I learned. Um, but if you are seriously um considering prosecuting a federal lawsuit, if you believe that your rights have been violated and you're thinking about filing a federal lawsuit and you want to learn how to do it, you need to sign up for that membership because I'm going to teach you. I'm going to screen share it. That's why I bought this computer for y'all, man. I'm going to teach y'all. It's $97.50 a month. It's a 12-month course. I think 12 months is pretty good. Some people might not need 12 months. Some people might need 3 months. Some people might need 6 months. Some people might need 9 months. I don't know. But I believe 12 months. I believe 12 months is good. I believe 12 months is good. To get y'all to understand this stuff. I'm going to, when I tell y'all, the only thing that you're going to have to do is read and practice drafting your motions and the complaint and stuff like that. You're going to have me for a whole 12 months. I might do a live maybe in regards to, to all the members who sign up for the course. I'm thinking about either doing one live a week or maybe two a week. Um, and I know it's going to be either 2 hours. I might just do it like that. I might just do one live a week, 1 3-hour live a week. I think I'm gonna just do something like that. I think 3 hours is enough. So have all your questions ready, have everything ready, and I got you. I'm gonna be providing y'all with the cases that you need to know. I'm going to be providing you with a format of the documents, how they're supposed to look that you need to know, the rules, the law dictionaries. I'm gonna give you every damn thing, everything, and I'm going to be talking to you, and I'm going to be providing you commentary on cases that you want to know, stuff like that. But you're going to have to read and you're going to have to practice this stuff at home on your own because they're going to test you when you file this lawsuit. They're going to get your ass in either they're going to use some tool of discovery to get you to admit that you don't know what the hell you're doing. So that's why I want you to know what you're doing because they going to test you. They test me. This man asked me at my deposition. He says, you said that you were detained without reasonable suspicion or you were unlawfully arrested or something to that effect, or unlawfully detained. His attorney. He says, what do you mean by that? I said, what do you mean? He says, like reasonable suspicion. I was like, do you mean like do you want to know what reasonable suspicion is or something like that? I think he said something like that. And he was like, yeah, what do you mean? And I said, well, reasonable suspicion is predicated upon specific articulable facts that a crime has been, is being, or is about to be committed. I said, I told you I knew this stuff. He was quiet, for a little minute when I said that. And he just started asking other questions. He was testing me to see if the reason they're asking you these questions is because that goes to, let me pull up this rule for y'all right quick. I told y'all I was going to leave, but shit. Let me pull up this rule for y'all right quick because I told y'all I was going to leave, but I'm not, evidently. Not right now. We're going to go to Google. I'm going to screen share it with y'all too and provide y'all some commentary on it. Where we at? Federal rules of evidence right here. Here we go, right here. I'm gonna show you the rule that that they're trying to use. They're testing you. That's what they're doing. Now, these rules right here, when you are litigating a federal lawsuit, these rules governs the admissibility or inadmissibility of evidence in your case. This is how you make objections using these rules right here. So where's the rule I'm looking for? Where is it? Witness. Here we go, right here. Witness. Okay. Everything in your complaint, and I mean everything in your complaint, is subject to being contested because you are a witness. So they're gonna test you. Competency to testify in general. Need for personal knowledge. So let's just go right here. Every person is competent to be a witness unless these rules provide otherwise. But in a civil case, state law governs the witness's competency regarding a claim or defense for which state law supplies the rule of decision. So let's go back. So they're saying every person is competent to testify unless these rules provide otherwise. So let's go and see what they're talking about. Need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Do you not have personal knowledge of your rights being violated? You're right there. You're standing right there. You're watching them violate your damn rights. You're a witness. So you have firsthand personal knowledge, and you're competent to testify as to the facts or as to those allegations that you made in that complaint. Evidence to prove personal knowledge may consist of the witness's own testimony. You're a witness. This rule does not apply to a witness's expert testimony under Rule 703. And then you can go down and read some more of this stuff. They're providing you with commentary and stuff like this. Let's go right here. Notes for Advisory Committee on Proposed Rules. The rule requiring that a witness who testifies to a fact which can be perceived by the senses must have had an opportunity to observe and must have actually observed the fact is a most pervasive manifestation of the common law insistence upon the most reliable sources of information, so on and so forth. Like it's just stuff for you to read, whatever. But that's what they testing you on when they ask you that stuff. That's what they test you on. This is how you make your objections. You're gonna use these rules right here. These rules. When you pay for that membership, that $97.50, we're gonna go over all of these applicable rules that I think we need to go over. They're gonna test you. They're gonna test you. They're gonna see if you know what you're talking about. They're gonna see if you are a supreme litigant. That's what they're gonna see. A supreme pro se litigant, so to speak. They're gonna test you. That's what they're gonna do. Let me turn this camera off. Turn this screen off. All right. Yeah, I appreciate it, man. I appreciate it. Okay, y'all. I'm serious this time. I'm about to go ahead and go. Everybody enjoy your weekend. Stay safe. Stay dangerous. You know how we say in the hood, if you're in the hood. And love on your family while they still here, man. Peace to the motherfucking gods. The supreme litigant is out. Peace.